Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a lot of people send me this story, so thank you very much. And of course, it's for good reason. The Taco Tuesday wars are over. Taco Bell and Taco John's dropped their Taco Tuesday fight. I did a story about this a while back about how Taco Tuesday, which is a phrase a lot of people use, apparently was claimed by Taco John's a while back, and not a lot of people knew that. And so Taco Bell apparently wanted to do something with Taco Tuesday and realized that a competitor actually owned the rights to that. And that's where the war began, my friends. Jordan Valinsky writes for CNN Business at Taco John's, the regional chain that has Taco Tuesday trademarked, announced Tuesday it's ending its fight and defending the phrase and will abandon it because it doesn't want to pay the legal fees that come with a fight against Taco Bell. And yes, they announced that on Tuesday. We've always prided ourselves on being the home of Taco Tuesday, but paying millions of dollars to lawyers to defend our mark just doesn't feel like the right thing to do, Taco John's CEO said in a statement. Taco Bell had filed a petition in May with the U.S. Patent and Trademark Office to cancel the trademark owned by rival Taco John's, and they've had it for 34 years because Taco Bell claims the commonly used phrase should be freely available to all who make, sell, eat, and celebrate tacos. As a result of the trademark being abandoned, the people from Taco John's said that they're donating $40,000 to Children of Restaurant Employees. And that's a nonprofit organization that supports restaurant workers with children by providing financial relief when either the employee, spouse, or a child faces a life-altering health crisis, injury, death, or natural disaster. And that's Taco John's official statement. And you'll notice, of course, that has nothing to do with the original fight here. But I think they just recognize, hey, look, we got 3 more minutes of this 15 minutes of fame here nationally. We may as well put it to good use. And I salute them for that. Taco Bell did not immediately respond for comment regarding the fact that the war is now over. Taco John's has owned the trademark in every state except for New Jersey since 1989. It has used the phrase for marketing purposes and has defended its use of the phrase and sent cease and desist letters to others who wanted to use it. But Taco Bell took issue with that and said that nobody should have exclusive rights in a common phrase and that any restaurant should use it. Trademark attorney John Gerben told CNN that Taco John's decision is not surprising because the phrase became ubiquitous in the marketplace, and any attempt to enforce the trademark registration would likely have failed in court. Therefore, the trademark registration had little, if any, value left at this point in time. If the case was litigated to the end, Taco John's could have suffered a significant public relations loss, as well as the loss of the legal fees. By bowing out of the court fight at this point, given the low probability of winning, Taco John's can work to control the court of public opinion around the issue. And yeah. That's a great explanation there. And so in case you don't know, there is the U.S. Patent and Trademark Office, the USPTO as we call it. And they are the ones who keep track of registered trademarks. And so you contact them and you file an application and say, here is the trademark I would like to use, and I'd like to trademark this. And it can be, the name of a product or something, or it could be your company's slogan or something that you're going to use in marketing your products. And in case you're curious about this, it goes way, way back. Trademarks go way, way back. In fact, trademark, you'll notice the word mark there, probably goes back to a time when most people were not literate. And so if somebody had a product that they sold, the way they would make sure their market, that their products were visible in the marketplace is they'd put a mark on it. And the mark would identify it in the trademark. And that way somebody could walk into a marketplace and recognize the trademark of a vendor that they trusted. And so it probably goes back that far. And so the way it works, though, is that in Washington at the USPTO, when you have a trademark that you want to register, they don't exactly tell you that, oh, by the way, we're granting this to you and we assure you that this will be trouble-free from here on out. Because there's a big gray area where people will submit a trademark And the people at the USPTO will glance through the files they've got and go, okay, nobody's trademarked it yet. So there you go. It's available. But they don't exactly go out and do marketing studies to find out how well something is known as associated with one particular company versus being widely used. And so Taco Tuesday, I think most people were surprised to hear that had been trademarked by anybody. And then apparently if you had used this too openly, you may have gotten a cease and desist order from Taco John's, and you go, wait, these guys trademarked that? When? So it probably was not defensible, meaning that they could have gone to court and fought it, but they would have probably lost, probably. And so one of the things that a lot of people I hear complain about in the field of trademark law is they'll say, hey, I heard about a guy, a little mom and pop shop or a little sole proprietor someplace, and he was running his business, and he got a cease and desist letter from a huge corporation telling him to stop using a phrase, stop using a word, stop using a symbol. I know there's big car companies out there where if you open up a shop and say, I specialize in repairing these cars, if you put the symbol of the car up and they find out about it, they'll send you a cease and desist and say, you can tell people that you repair our cars. You cannot use our trademark, because putting up our trademark on the side of your shop implies that we are endorsing you, that somehow we're behind you. And also, it dilutes the mark, is what they call it. And that means that the more people use the mark without permission, the easier it is for someone to come along and say, look, other people are doing this. Look at all the people who are doing Taco Tuesdays. Taco Tuesday is a meme on Facebook, and so at the point it becomes a meme on Facebook, you've probably already lost in the court of public opinion. So it'd be hard to imagine a court looking at this going, oh, you guys trademarked Taco Tuesdays 34 years ago. And, here we are today, and yeah, you're right, Taco Bell can't use that. And of course, in this battle, Taco Bell would be the Goliath, and Taco John's would be the David. And I suspect Taco Bell would have won. And that's the other thing about this, is that the field of trademark law kind of becomes self-help, meaning that somebody trademarks something, and other people look at it and go, that trademark is not defensible. Well, until somebody takes it on. And so it takes somebody who has the wherewithal to say, I want to go after this and have the trademark office strike this down. And so until that happens, it can remain on the books. And so we've heard of people who have trademarked things that shouldn't have been trademarkable in that sense, but they get trademarked simply because no one else trademarked it before and somebody applied for it. And I can think of some other examples also, but Taco Tuesday, I would think, is something that most people would say, no, that can't be trademarked, and they can't claim that identifies something to do with Taco John's, because quite frankly, until I did this story, I didn't know Taco John's existed. So to suggest that, they're the ones who are identifiable with Taco Tuesday, no. But the one thing, I don't think I mentioned this in the last video I did, and the one thing that's blown my mind, and I only learned this recently, and this may blow your mind too, so perhaps you should sit down. But if you have a pencil and paper, you can double check my math on this. Taco cat, spelled backwards, is likewise taco cat. So I don't know if anybody has tried trademarking taco cat, but it is in fact mind blown. So thank you for everyone who sent this, but the taco wars are over. Taco Bell and Taco John's have dropped their Taco Tuesday fight. And Taco John's, in a very, very classy move, has stepped up and said, we're not going to fight this. It's not worth it. But while we've got your attention, we are donating $40,000 to the children of restaurant employees. It's a good cause, and perhaps you should consider doing the same. So some goods come of it. And luckily, like I said, the battle is over. We can just go back and enjoy our Taco Tuesday as we see fit at the restaurant or place of our choice. Questions or comments, put them below. Those. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Oh, I used to be confused, but now I just don't know.